Okay, moving on to our action items. Item number 13, consider adoption of Resolution 2018-05 regarding State Water Resource Control Board Order WR 2009-0060.
Thank you. And just for everyone to know, in addition to the notice that was received in closed session, you did receive 2 sets of emails, I believe, from a citizen from Pacific Grove, a letter from California American Water, which was delivered today, an email from the State Water Board's General Counsel, Michael Offer, which was received today, a letter of support from the City of Monterey, and in front of you on the table is a letter of support from the Coalition of Peninsula Businesses. So you may not have had time to digest all of those things, but they should be viewed in concert with the staff note and the discussion that we're going to have. The resolution itself is really a novella that pretty much describes everything that has taken place. And I think if you've read it, it's a pretty good narrative. But I do want to highlight that this is about a failed process. California American in November of 2011 asked the state for some interpretive language on Condition 2 of the then cease and desist order. That condition is about 3 sentences long, and we got back a 4-page letter. It's important to note that that letter was sent to California American, not sent to the district. So in terms of being a public document, it was not. Nevertheless, we did receive a copy. It's important to understand that this resolution does not change Condition 2, leaves it intact, and it's not proposing to change Condition 2, nor does it change any district rule. It just reinforces the district rule as a mechanism on how to interpret Condition 2 as drafted and put into the order. And the problem is, as I mentioned, there's been a failed process. The answer to that November 2011 letter was an April 2012 letter, which proposed a framework that was not enforceable, not logical, and quite possibly not legal with respect to the obtaining of specific records for account holders on a property. Nevertheless, that's been the guidance for how to interpret Condition 2 as it relates to existing service connections for a change or an increase in water use due to a change in zoning or use. Early 2013, we at the district expressed our concerns that the interpretation was not working, was not workable, was illogical, and possibly unlawful, entered into discussions that led to no new guidance. At the hearings for the extension of the cease and desist order, and this is both in the resolution and in the staff note, about 20 local community leaders, some of whom are represented in here, expressed support for extending the CDO and asked for final clarity for a set of ground rules on how to interpret an increase in use due to a change in zoning or use at an existing service connection. During that proceeding, the provenance or the basis of the April 2012 letter was called into question by Director Dee Diadamo, the board member Dee Diadamo, as well as other members of the public who spoke. And in fact, a section of the proposed order was removed that referred to that letter and a subsequent letter in March of 2013 to the district, which also didn't have any effect because it basically said, until you provide more information, we're not going to take action. That second letter to the district. So by its removal, it calls into question the efficacy of the original letter, yet that's still what California American is using to value its decisions about an increase in use in an existing service connection. Spoke with General Counsel Michael Offer today, and the State Board does recognize that they kind of dropped the ball on this, that in fact there is some question as to how to interpret this, that the framework may be difficult to actually interpret, or the thinking that they've had, and we've spent a lot of time trying to convince him of why the district's method of accounting water and its water neutrality, there's no new water, we're not giving away any water that isn't currently in the system, would work better. And he advocated for getting together as soon as possible. You can see his position on tonight's vote in that email. Nevertheless, in front of you is a resolution on which you can act, not act, defer, or adopt with a deferred effective date. That's all I have.
All right. Does the board have any questions of staff? Okay, I'll go ahead and open up public comment. Please limit your time to 3 minutes.
Thank you, Director. Eric Sabolsi, Director of Operations for California American Waters. Dave mentioned I sent a letter to each of you today specifically to this item. I wanted to share a few additional comments, not recited verbatim, but just, again, provide a summary of arguments of this proposed action for tonight. And I thought it was the discussion about water use factors and how you would apply those was interesting to listen to in the debate about metering use at a business or using water use factors and which of those what might be most appropriate. It can get there's a lot of different opinions, a lot of different views about how this should occur, and I think we're just looking for everyone to get to some agreement. But this proposed ordinance puts Cal-Am in a tough spot with both the CPUC, where we have a moratorium, and the State Water Resources Control Board, and jeopardizes the conditions upon which the State Water Resources Control Board authorized Cal-Am to continue its diversions when the CDO was extended. We understand the district's frustration with the State Board's interpretation of Condition 2 from the 2009 cease and desist order, and we're willing to continue to work to resolve. We risk substantial fines and potentially an injunction restricting our diversions by more than 5,000 acre-feet if it fails to comply with the terms of the cease and desist order. Cal-Am will work with the district in any way possible within the requirements of the law to meet the needs of the Monterey Peninsula. We're concerned this resolution could put Cal-Am in the position of risking the water supply security that the community currently has under the extended CDO. We urge the board to table this resolution until it can obtain certainty with the State Board, as Dave mentioned, through his discussions with staff there, so that we don't jeopardize the current water supply that we have under the CDO extension. Thank you.
Thank you.
Sorry if I'm walking wild bad back. Tom Raleigh again, representing MPTA. We know that, and the staff report, and as explained by General Manager Stolt, really shows, the lack of action by the staff, State Water Resources Control Board, and actually the onus still goes on the board itself. And we know there's been some changes in that board over the last, whatever, probably since the CDO. I doubt if there's anybody left since 2009. But anyway, the concerns by Mr. Sabolsi of Cal-Am, I think, are real. And the last thing we want to do is get anybody that's controlling our water future mad at us. So I would hope that you would weigh his recommendations very, very carefully. I know it's always tempting to adopt the damn the torpedoes, full speed ahead mentality, but, in this case, you're really looking out for the future of the community. I had hoped that there would be somebody here from the Monterey Peninsula Regional Water Authority, the mayor's group, but there isn't, to express their attitude. And so I would hope maybe during discussion that Mr. Rubio, as a member of that group, would give us at least what you believe their opinion would be. So anyway, I guess what I'm urging is that don't adopt the damn the torpedoes. I mean, that's a good old Navy thing, and occasionally we like to do that down here, and we dig a hole for ourselves. So I guess what basically our organization is urging is be very, very cautious about what decision you make. Thank you.
Mr. Ali?
Mr. Chair, Directors, John Narigi, Chairman, Coalition of Peninsula Businesses. I've read the entire resolution. You also have a letter that I submitted this morning. Coalition took part up at the state. I think we attended 3 meetings. I can't remember how many conference calls, privates, and I can't agree with Cal-Am, and I can't agree with Mr. Raleigh's comments. We have waited and waited for over 2 years to get an answer from staff. We have done everything in our power as a community, as a district, to follow the rules. Sadly, the way it was interpreted prior to the hearing at the state level, there were actually no problems with it. It was interesting, the conversation we just had recently regarding the new T-zone and juice bar. That kind of plays into condition 2 right then and there. I believe General Manager Stoltz said, we have the water. But you as a body responsible to secure our water, protect our water, do not have the authority to make a simple call regarding a T-zone. I also believe the state has really already ruled on this topic. I have to ask how the Monterey Bay Aquarium's Educational Center got approved when Condition 2 was tossed out. I find that appalling. Not that it's the aquarium, I think it's a beautiful building, it's right next door, and I'm thrilled to have it. But talk about a break in policy. So who suffers? It's the little guy that suffers. They're the ones that are penalized. And we also have the Holman building in PG that's also gone through quite a dissertation and conversation about different uses. Well, that's really what Condition 2 is all about. We have done a superb job in this community, and I don't think it's, I think the community is what's frustrated, not necessarily water management, as Cal-Am stated. I know myself as a business person, when I'm dealing with retailers coming into the hotel, it's a frustration. The small business owners, it's a frustration. Because of Condition 2, people are losing money on their lifelong investments because nothing can be done. I strongly believe it's the position and the place for the district to step up and challenge the state. Have they done us any favors yet as it relates to our water supply project? CPUC, State Water Resources Control Board, I don't think so. I really think it's time we stand up in community and say enough's enough. We have records that when this district interpreted Condition 2, we had no problems. We're not going to take any additional water out of the Carmel River. That in itself takes care of the CDO. I urge you to approve the resolution that you have this evening and move forward for the betterment of this community. Thank you.
Mr. Narigi? Anyone else for public comment?
Luke Coletti, resident of Pacific Grove. I suggest you table this as well. I think this is a preemption. It's an attempt to flex your muscles where you have none. And it's not a failed process. It's a failure not to get the answer you want. And I think all the comments that you hear and all the comment letters, even the general manager's staff report, which I think is riddled with misinformation. It's articulating that frustration. I didn't get what I wanted, and the state's the bad guy, and we're going to fight them, blah, blah, blah. The thing is, the CDO is kind of a mess. It's a messy business, you know, but it's going to be over one day. So let's play by the rules. Follow Condition 2. It's not as onerous as some are saying. And the issue about the aquarium, they don't even understand what it's doing. What Condition 2 says, if it's a change in zoning or use, And the use in this case would be going from residential or to commercial or vice versa. It stayed a commercial use. It didn't, the aquarium building did not go into a residential use. So that's why condition 2 didn't apply to the, and it's just a red herring, and every time I hear it, it's just more silliness about this whole thing. The other issue is about the 2012 and the 2013 guidance letters that came from the state. It articulated the position about condition 2, how it was interpreted. The district never put them on their website, so how was the public going to know about it? They never could, because you guys never informed the public. That's on you. It's not on the state. And the issue about going up to Sacramento, I was up there for the July 19th extension hearing. This isn't a popularity contest where you get a bunch of people on a bus, get up to a microphone and say, hey, you know, let's change condition 2. They don't even understand what condition 2 is. But yet, they had their bus ride, and now they think they're entitled to have the state do what they say. As you know, the Sierra Club submitted a letter potentially reopening the stipulated settlement agreement. Why go through all this? Focus on getting a water supply. Condition 2 eventually goes away. This isn't something we have to live with forever. And I think what's happened here is the district manager or the general manager has promised water that he can't develop or deliver. And now the only way to get it is through condition 2 and breaking faith with the Pacific Grove Local Water Project as well, by the way. I mean, the state is just alerted to all these shenanigans, so just stop it. Find a water supply. Condition 2 eventually goes away. We'll all be happy. Thank you.
Thank you. Any other public comment?
I'd like to support the business community who thinks that where the rubber meets the road in the local community, you are the best judge of what can be monitored, what can be accounted for, what can happen at the local level. And all water should be local. Local decisions ought to be the priority as much as it can take place. If you have an opportunity to wade in on an interpretation and stick with it, and you can defend the position that you're taking, I say do it. Because in the final conclusion, it's a local issue. You're the ones that are the expert on that, not the State Water Board. So regardless of what their interpretation or lack of response or whatever it is, I think you have every right to interpret how you think it can work and how you can control within the limits of the CDO at the local level. And if you feel like you can do that, I hope you do that.
Thank you.
My name is Scott Dick. I'm the Government Affairs Director for the Monterey County Association of Realtors, and I came up to support John Narigi and General Manager, and I find myself astonished that I'm in agreement with George Riley on this issue. So I was there, heard the discussion. It's not the same. It's when we talk about change in use and change in zoning, change in use is not as simple as it seems. It's not from business to residence. It could be, what if before there was a facility that uses a lot of water, then it was replaced by a retail. So, and then you want to bring something else that uses more water, then we have to consider that it was retail in there before. We can't go back and look in the historical documents. And so it's the kind of, it's nuanced. And I support both John Narigi and, like I said, George Riley. This is really weird. Thank you.
Woodward from the Public Trust Alliance. I was surprised here too, but the interpretation can't go dancing all over the world to change the amounts of water. And what's happened during this application process for the PUC is that there has been a tremendous change in circumstances, and many of the things which made sense to have a desal plant when the regional project was proposed and to have a publicly owned and operated desal plant have totally changed because of the change in both institutional and environmental circumstances. And Luke is exactly right that there has been a bus going up to Sacramento for years. And it's a give us what we want option. And this district is not in the position of giving us what we want, because actually it's the broader public which actually has that water in trust for its interests. And the state is the representative of those interests and will protect them. And a bunch of people going up saying this is the way we want to understand water in this state, that has a problem, because it's never been like people are trying to understand it. And I think it's incredibly important here to pull back and concentrate on getting an actual water supply and not trying to create new definitions to work corners. So I think that this should be tabled for the time being.
Thank you. Any other public comment? Okay, seeing no public comment, we'll close public comment.
Mr. Chair, may I address a few of the public comment items? It was mentioned that there's concern over the moratorium established by the PUC. This would have no effect on the moratorium. We recognize the moratorium on new connections, so that remains intact. This is not about not getting what we want. We didn't get an answer. There was a 60 to 90-day commitment in the motion that was made for the extension of the cease and desist order, and we didn't get an answer. The aquarium building would, in fact, fall under the definition of a change in use in the April 2012 letter. This goes to what I've advised you on about selective reading of that April 2012 letter. Going from commercial to commercial is not the litmus test. It's change in use by a local land use organization or the district, and it would clearly fall under change in use. Putting letters on the website wouldn't matter because the letters created confusion in both the way they were interpreted, which sections were read and which ones were ignored, and that would have persisted. And again, the letter was not sent to us, it was sent to Cal-Am. We are not talking about changing Condition 2. That was stated by one of the speakers that we're trying to change Condition 2. We promote leaving Condition 2 intact. And when they say, hey, it's not going to be forever, let's focus on an actual water supply, there is the potential for litigation that may leave us 5 years out until it's resolved with 3 years to build. That's an 8-year period. We need to have a plan to interpret what property owners and business owners can do for that period of time. This has nothing to do with Pacific Grove. I'm sure Pacific Grove will start to endeavor down a path to work on its own local water project entitlement, but this particular issue has been festering since 2012, before the local water project was even a vision in Pacific Grove's mind. And it would have made more sense to take a bus, which we haven't, because we probably had 31 different cars leave Monterey to go to the commission hearing, and we don't just get together and go up and do a cheerleading to try to get what we want. And finally, I don't think it's fair to have someone lecture us on following the rules when he was caught on videotape stealing campaign signs.
That's a lie, goddammit. You know it.
Please come to order, sir. Sir, please come to order. Sir, excuse me, sir, can you please leave if you're going to act that way?
I don't expect to have the...
I don't expect you to be out of order, so can you please? Yeah, let's take a 5-minute break.
That's all you got, right, Stoll? Just lie about me?
I saw the video.
There was nothing stolen whatsoever, and you know that. I took 2 signs and put them on the front doorstep of the Chamber of Commerce. Nothing was stolen.
Looked like they went in the back of a pickup truck.
You're a liar. You're a goddamn liar, Stoll. And that's all you got.
That's all I got. I know, a little out of line, I apologize.
And I tried.
I heard you.